Today I am present in front of you with another part of outstanding features of our constitution. Parliamentary government combined with an elected president at the head. As the constitution of IRE, the Indian constitution superimposes an elected president upon the parliamentary system of responsible government. But though an elected president is the executive head of the union, he is to act on the advice of the ministers, although whether he so acts according to the advice of his ministers is not questionable in the courts, and there is no mode short of impeachment to remove the president if he acts contrary to the constitution. On the other hand, principle of ministerial responsibility to the legislature, which under the English system rests on convention, is embodied in the express provision of our constitution, that is Article 73, subsection 3 of the Constitution. In the words of our Supreme Court, our Constitution, though federal in its structure, is modelled on the British parliamentary system, where the executive is deemed to have the primary responsibility for the formulation of government policy and its transmission into law. Though the condition precedent to the exercise of this responsibility is its retaining the confidence of the legislative branch of the state. In the Indian Constitution, therefore, we have the same system of parliamentary executive as in England. But our Constitution is not an exact replica of the Irish model either. The Constitution of Ireland lays down that the constitutional powers of the President can only be exercised by him on the advice of ministers, except those which are left to his discretion by the Constitution itself. Thus, the Irish President has an absolute discretion to refuse dissolution of legislature of a defeated Prime Minister, contrary to the England practice. The practice and convention, but in the Indian Constitution there is no provision authorizing the President to act in his discretion on any matter. On the other hand, by amending Article 74(1), the 42nd Amendment Act has explicitly codified the proposition which the Supreme Court has already laid down in several decisions, that the President shall, in the exercise of his functions, act in accordance with such advice, that is the advice tendered by the Council of Ministers. The Janata government has preferred not to disturb this contribution of the 42nd Amendment, except to empower the President by 45th Amendment 1978 to refer a matter back to the Council of Ministers for reconsideration. 14. Perhaps the most remarkable achievement of the Indian Constitution is to confer upon a federal system the strength of a unitary government, though normally the system of government is federal. The Constitution enables the federation to transform itself into a unitary state by assumption of the powers of states by the Union in Emergencies, Part 18. Such a combination of federal and unitary systems in the same constitution is unique in the world. For the correct appreciation of this unique system, it is necessary to examine the background upon the federalism has been introduced into India. In the light of the experience in other federal countries, that this deserves a separate treatment. Chapter 5. 15. No less an outstanding feature of the new constitution is the union of some 552 Indian states with the rest of the India under the constitution. Thus, the problem that baffled the framers of the Government of India Act 1935 and ultimately led to the failure of its federal scheme was solved by the framers of the constitution with unique success. The entire subcontinent of India has been unified and consolidated consolidated into a compact state in a manner which is unprecedented in the history of this country. The process by which this formidable task has been formed makes a story in itself. As the time of the constitutional reforms leading to the Government of India Act 1935, the geographical entity known as India was divided into two parts, British India and Indian states. While British India comprised the 9 governors, provinces and some other areas administered by the Government of India itself, the Indian states comprised some 600 states which are mostly under the personal rule of the rulers or proprietors. All the Indian states were out of the same order. Some of them were states under the rule of hereditary chiefs which had a political status even from before the Mohammedan invasion. Others, about 300 in numbers, were states or jagirs granted by the rulers as rewards for services or otherwise to particular individuals or families, but the common feature that distinguished these states from British India was that the Indian states had not been annexed by the British Crown. So while British India was under the direct rule of Crown through its representative and according to the statutes of Parliament and enactments of the Indian legislature, the Indian states were allowed to remain under the personal rule of their chiefs and princes under the suzerainty of the crown, which were assumed over the entire territory of India when the crown took over authority from the East India Company in 1858. The relationship between the crown and the Indian states since the assumption of suzerainty by the crown came to be described by the term paramountcy. The crown was bound by engagements of a great variety with the Indian states. A common feature of these engagements was that while the states were responsible for their own internal administration, the crown accepted responsibility for their external relations and defense. The Indian states had no international life, and for external purposes they were practically in the same position as British India. As regards internal affairs, the policy of the British Crown was normally one of non-interference with the monarchical rule of the rulers, but the Crown interfered in cases of misrule and maladministration as well as for giving effect to its international commitments. So even in the internal sphere, the Indian states had no legal right against non-interference. Nevertheless, the rulers of the Indian states enjoyed certain personal rights and privileges and normally carried on their personal administration unaffected by all political and constitutional vicissitudes within the neighboring territories of British India. The Government of India Act 1935 envisaged a federal structure for the whole of India in which the Indian states could figure as units together with the governors' provinces. Nevertheless, the framers of the Act differentiated the Indian states from the provinces in two material respects, and this differentiation ultimately proved fatal for the scheme itself. The 2 points of difference were while in the case of the provinces, accession to the federation was compulsory or automatic. In the case of an Indian state, it was voluntary and depended upon the option of the ruler of the state, while in case of the provinces, the authority of the federation over the provinces, executive as well as legislative, extended over the whole of the federal sphere chalked out by the Act. In the case of the Indian states, the authority of the federation could be limited by the instrument of accession, and all residuary powers belong to the state. It is needless to elaborate the details of the plan of 1935, for as has been stated earlier, the accession of the Indian states to the proposed federation never came true, and this part of the act was finally abandoned in 1939 when the World War II broke out. When Sir Stafford Cripps came to India with its plan, it was definitely understood that the plan proposed by him would be confined to settling the political destinies of British India, and that the Indian states would be left free to retain their separate status. But the cabinet mission supposed that the Indian states would be ready to cooperate with the new development in India, so they recommended that there should be a union of India embracing both British India and the states, which would deal only with foreign affairs, defense and communications, while the state would retain all powers other than these. When the Indian Independence Act 1947 was passed, it declared the lapse of suzerainty paramountcy of the Crown in 7(1)(b) of the Act, which is worth reproduction. As from the appointed day, the suzerainty of His Majesty over the Indian states lapses, and with it all treaties and agreements in force at the date of the passing of this act between His Majesty and the rulers of Indian states. All functions exercisable by His Majesty at the date with respect to the Indian states, all obligations of His Majesty existing at that date towards Indian states or the rulers thereof, and all powers, rights, authority or jurisdiction exercisable by His Majesty at that date in or in relation to Indian states by treaty, grant, usage, sufferance or otherwise end, provided that notwithstanding anything in paragraph B of this subsection, effect shall as nearly as may be continue to be given to the provision of any such agreement as therein referred to, which relate to customs, transit and communications, posts and telegraphs or other like matters, until the provisions in question are denounced by the rulers of the Indian states on the one hand, or by the dominion or province or other part thereof concerned on the other hand, and or superseded by subsequent agreements. But though paramountcy lapsed and the Indian states regained their position which they had prior to the assumption of suzerainty by the Crown, most of the states soon realized that it was no longer possible for them to maintain their existence independent of and separate from the rest of the country, and that it was in their own interests necessary to accede to either of the two dominions of India and Pakistan. Of the states situated within the geographical boundaries of the dominion of India, all numbering 552 save Hyderabad, Kashmir, Bahawalpur, Junagadh and northwest province states Chitral, Phulra, Dir, Swat and Amb had acceded to the dominion of India by the 15th August 1947, that is before the appointed day itself. The problem of the government of India as regards to the states after the accession was twofold, shaping the Indian states into sizable or viable administrative units and fitting them into the constitutional structure of India. The first objective was sought to be achieved by a threefold process of integration known as the Patel scheme. After Sardar Vallabhbhai Patel, Minister in charge of Home Affairs, 216 states were merged into the respective provinces geographically contiguous to them. These merged states were included in the territories of the states in Part B in the first schedule of the Constitution. The process of merger started with the merger of Odisha and Chhattisgarh states with the then province of Odisha on January 1, 1948. And last instance was the merger of Cooch Behar with the state of Bengal in January 1950. 61 states were converted into centrally administered areas and included in Part C of the first schedule of the Constitution. This form of integration was resorted to in those cases in which, for administrative, strategic, or other special reasons, central control was considered necessary. The third form of integration was the consolidation of groups of states into new viable units known as Union of States. The first union formed was the Saurashtra Union, consolidating the Kathiawar states and many other states, February 15, 1948, and the last one was the Union of Travancore Cochin, formed on July 1, 1949. As many as 275 states were thus integrated into 5 unions: Madhya Pradesh, Madhya Bharat, Patiala and East Punjab State Union, Rajasthan, Saurashtra and Travancore Cochin. These were included in the states of Part B of the first schedule. The other 3 states included in Part B were Hyderabad, Jammu and Kashmir and Mysore. The cases of Hyderabad and Jammu and Kashmir were peculiar. Jammu and Kashmir acceded to India on October 26, 1947, and so it was included as the state in Part B, but the government of India agreed to take the accession subject to confirmation by the people of the state, and a constituent assembly subsequently confirmed it. In November 1956, Hyderabad did not formally accede to India, but the Nizam issued a proclamation recognizing the necessity of entering into a constitutional relationship with the Union of India and accepting the Constitution of India subject to ratification by the Constituent Assembly of that state. And the Constituent Assembly of the state ratified this. As a result, Hyderabad was included as the state in Part B of the first schedule of the Constitution. We have so far seen how the states in Part B were formed as viable units of administration, being the residue of the bigger Indian states left after the smaller states and had been merged in the provinces or converted into centrally administered areas. So far as the latter 2 groups were concerned, there was no problem in fitting them into the body of the Constitution framed for the rest of India. There was an agreement between the government of India and the ruler of each of the states so merged, by which the rulers voluntarily agreed to demerger and ceded all powers for the governance of the states to the Dominion government, reserving certain personal rights and privileges for themselves. But the story relating to the states in Part B is not yet complete. At the time of their accession to the Dominion of India, 1947, the states had acceded only on 3 subjects, viz. Defense, foreign affairs and communication. With the formation of the unions and under the influence of the political events, the rulers found it beneficial to have a closer connection with the Union of India, and all the Raj Pramukhs of the unions as well as the Maharaja of Mysore signed revised instruments of accession by which all these states acceded to the Dominion of India in respect of all matters included in the Union and concurrent legislative list, except only those relaxing to taxation. Thus the states in Part B were brought at par with the states in Part A, subject only to the differences embodied in Article 238 and the supervisory powers of the center for the transitional period of 10 years. Special provisions were made only for Kashmir, Article 370, in view of its special position and problems. That article makes special provisions for the partial application of the Constitution of India to that state with the concurrence of the government of that state. It is to be noted that Raj Pramukhs of the 5 unions as well well as the rulers of Hyderabad, Mysore, Jammu and Kashmir all adopted the Constitution of India by proclamation. The process of integration culminated in the Constitution's 7th Amendment Act 1956, which abolished Part B states as a class and included all the states in Part A and B in one list. The special provisions in the Constitution relating to Part B states were consequently omitted. The Indian states thus lost their identity and became part of the one uniform political organization embodied in the Constitution of India. The process of reorganization is continuing still, and the recent trend is towards conceding the demand of smaller units which were previously Part B states. Union territories are autonomous part of states by conferring upon them the status of a state, as for example Nagaland, Meghalaya, Himachal Pradesh, Manipur, Tripura, Mizoram, Goa. Delhi has been made the national capital territory. This process will be further elaborated in Chapter 6, Territory of India. Before closing this chapter, however, it should be pointed out that since the observations in the case of Golaknath culminating with Keshavanand, the Supreme Court has been urging that there are certain basic features of the Constitution which were immune from the power of amendment conferred by Article 368, which, according to the court, was subject to implied limitation. On the other hand, the Indira Gandhi government had been attempting to thwart this doctrine by successive amendments of Article 368, starting with the 24th Amendment 1971 and ending with 42nd Amendment Act 1976, so as to obviate any such conclusion by the Supreme Court. The court has, however, adhered to its view. Notwithstanding any of these amendments, the present chapter does not enter into that controversy which will be dealt with the Chapter 10, Procedure for Amendment. The comparative study of any constitution will reveal that it has certain prominent features which distinguish it from other constitutions. It is those prominent features which have been summarized in this chapter by way of introducing the reader to the various provisions of the Indian Constitution. This is all about today's outstanding features of our Constitution and last part of the outstanding feature of our Constitution. Thanks, regards.